All right. So our next panel is titled NYC Alphabet Soup, Defending Parallel Investigations. You'll notice we're down a chair. Matt Podolsky is unable to attend today at the last minute, unfortunately, but we have the SDNY angle covered very well, as you'll see in a second. Our moderator is Brad Karp. He's the chairman of Paul Weiss, and he's been that since 2008, based here in New York. Brad is simply one of the country's leading litigators, corporate advisors, and focuses on the company litigation, regulation, internal investigation, and corporate crises, and we're really delighted to have you here, Brad. Thank you.
Thank you.
To Brad's left, Rebekah Donaleski.
You got it.
A partner with Cooley, also based in New York. She previously served as an AUSA in the Southern District of New York for 9 years, where she was chief of the Public Corruption Unit. Welcome, Rebekah. Next down is Jeff Kern. He's a partner at Sheppard Mullin in New York. He previously served as a senior regional counsel in FINRA's Department of Enforcement and senior trial counsel in the NYC's Enforcement Division, giving us some more alphabet soup there. Thank you, Jeff. And then finally, at the end there, Parvin Moyne, a partner at Akin, Gump in New York. And Parvin also previously served for nearly a decade as an AUSA in the Southern District of New York. Brad, thanks for moderating. Let me turn it over to you.
Perfect. Thanks very much, Bruce, and it's a pleasure to be here. Unlike the last panel, we are completely unconstrained, and we'll answer whatever you'd like to hear, talk about anything you'd like to hear. And this is an issue that, from the defense bar, is one that causes tremendous consternation, enormous frustration. It's part of our day-to-day existence. And even though the Department of Justice about 7 years ago created an anti-piling on policy, that appears to be much more in theory than in practice. So let me tee up the issue and then turn it over to my panelists. What do we mean by parallel investigations, defending parallel investigations? There's the federal angle. You've got Congress. Whenever Congress appears, Congress becomes an exigent priority. You've got the Department of Justice with all the disparate United States attorneys' offices. You have the SEC, the CFTC. If you're having banks, you've got the Fed, the OCC, the FDIC, the CFPB. If you have antitrust, you get the Antitrust Division, the FTC. You could really go on and on and on, and that's just within the federal realm. You'll often have state involvement. So then you have the 50 state AGs, and then you'll have subsidiary units. Like in New York, you'll have the New York Department of Financial Services, which traditionally has been quite active in certain areas. You have the global perspective. You'll have the FCA and the PRA in England, and you go country by country. So if you are representing a corporate defendant that is ensnared in a massive global investigation, it's hell to defend. It really is. And what I think we'd like to do over the next 40 minutes is walk you through the strategies, the decision-making, the challenges, how you decide to deal with voluntary self-reporting and the like. It really is complicated. There are no bright line rules or recommendations. Almost every situation is sui generis, and you have to customize your strategic responses. But we've got a great panel to walk us through. We're going to improvise a little bit because our government representative came down with the flu this morning. So I'm going to turn it over to Rebekah to start. You spent almost a decade in the Southern District U.S. Attorney's Office. You have been on the other side of this issue, working with lots of other actors. What's your perspective from a government perspective when you're looking at a very large global investigation and there are lots of fingers trying to get involved?
Right. So from the government side, when I was at SDNY, we encountered this all the time. And obviously, DOJ, SDNY, you think of yourself as top of the totem pole. Maybe you are, maybe you aren't. But you're concerned about other players coming in and affecting your criminal case, right? And so if someone takes testimony before you're ready for testimony to be taken, if someone calls a witness at a trial, that's usually bad for the criminal investigation. And so what's the remedy for that? more communication. Sometimes that works, sometimes that doesn't. And so from a government perspective, it is almost always complicating and more difficult, but unavoidable when you have these big hot button issues that everyone wants a small piece of.
Right, and Jeff and Parvin, when you're representing the government side and you have an interest in leading or helping to control the investigation, what are some of the tactics that you will use among your sister and brother regulators, and how do they manifest themselves when you're dealing with the defendant and the counsel for the defendant?
So I think Becca touched on it. It's about good communication. I think if you know the other parties, right, understanding what is their piece of the pie, what are they after, what's important to them, and you talk about it and you express what's important to you, and I think you put in some ground rules in place, and you stay in touch. And I think in these situations, I think it's easy for things to spin out of control. Actions can be misunderstood. And so I think, again, you have to over-communicate. I think you have to err on the side of picking up the phone and communicating exactly what you're doing, why you're doing it. And I think, there's a debate of forgiveness or permission. I think in this case, permission is probably the road to go because, again, you don't want to be seen as not being a team player in the bigger picture.
And Parvin, before you remove your government hat, let me ask one question. What are the biggest mistakes that you've seen defense counsel make in the context of parallel investigations? Is it lack of communication? Is it kind of not being completely open and candid about dealings with other regulators involved?
Yeah, I think that it can be very difficult, as we'll talk about in a moment, to be defense counsel in these situations, right? But you want to do your part to to be consistent, right? So if assume that the different government agencies are speaking, and make sure you're consistent in your message to all of them, because they're going to compare notes, and if it turns out that you said something different to one than another, you're going to be in a lot of trouble. And then you want to encourage them to collaborate, right? Because it's ultimately in your client's interest often, because you want one resolution, which we'll talk about in a moment. And so trying to be flexible and offering solutions can help. For example, offering I'm happy to make this presentation to all of you at once. We can host, or we can come to somebody's office, but we're certainly interested in having you all in the room and helping facilitate that. And if you make that overture, that can help the government in their job of working together and communicating.
And is there a practice, official or unofficial, of government regulators indicating which regulator or enforcement agency is likely to take the lead?
I would say sometimes yes, and that makes it sometimes easier, and sometimes no, right? Because they're not communicating, or there's not one clear sort of agency that has a primary interest, and there again, sort of from how defense counsel can be helpful to the government, it is trying to facilitate the communication so that there's some coordination.
Okay, getting rid of the government hat and turning to the defense bar. I genuinely believe that dealing with the multiplicity of federal, global, state enforcement authorities and regulators is the most challenging thing a defense lawyer comes up against in practice. Wearing your defense hat, how do you go about organizing the defense when you see 5, 6, 7, 8 regulators and enforcement agencies on the scene? What are your tactics and tips from the outset? Let's begin at the beginning of investigation.
So first, you need to prioritize the threat level. So you mentioned at the outset, Brad, Congress is at the top. Obviously, criminal is more of a threat to an organization than civil. But within there, you shouldn't be letting on that I perceive you as more of a threat than your fellow regulator. And so, again, I think from the outset, communicating, Parvin mentioned, we assume they're talking. from the government side, that's not true. You can't make that assumption. And so it's walking a line between making sure that each knows that the other is out there, has surfaced, and communicating what you're doing with respect to them. But then I think prioritization of threat is the number one tip, because you're making sure that you are complying with who could make your life the most difficult first, and ensuring that the others understand, we're going to comply with this criminal subpoena, happy to make the same production to your voluntary request, things like that. So communication and making sure that you are focusing your energy where it needs to be focused.
And one of the problems with Congress, when Congress decides to intervene early, when there's a major crisis, is Congress will swoop in, they will demand testimony within a matter of days or weeks, and you are forced to stake out positions, often with the senior most representative of your client, testifying under oath and locking in all manner of positions publicly that will then come back and bind the company throughout the remainder of the investigation. And that's why I've always viewed congressional involvement as one of the most frightening situations that can arise. I think you're going to see a lot more congressional investigation over the next 4 years than we have in recent past, because everything has been so overtly politicized. I don't know whether any of the three of you have had situations where you've had to bring a client into Congress when you have enforcement agencies, criminal enforcement agencies, regulators lying in wait, and what tips and tactics you have in that circumstance.
Yeah, I mean, at Akin, we actually have a group that specializes in this, who I work with closely when it happens, and it's really challenging, because testimony before Congress looks very different than testimony within, a deposition or an informal proffer in the government with the criminal authorities. And so when you have to do that early on, you're right, it's incredibly challenging, because there's a message that the company needs to put out, oftentimes before the internal investigation is complete and before you really know what all of the facts are. But it's not acceptable for the CEO to not have an answer, right? And so navigating that can be very challenging. I don't have a good answer for it, except, again, it's very challenging, and you want to make sure that your folks who are preparing somebody for congressional testimony are in close communication with the folks who are handling the criminal side, the regulatory side, and the like, to make sure that the testimony is not going to make matters worse.
Right. And there's a practical issue too. If you're representing a client, multiple enforcement agencies and regulators on the scene, you don't want your senior executives to be called in for interviews or to be giving testimony multiple times. You want to make sure that you're able to coordinate all of the discovery proceedings and interview processes as best as you can. What are the tips and tactics that you use to try to make sure that all of the different regulators and enforcement agencies accept one interview with someone taking a lead? And can you, if you're wearing your defense hat, can you achieve that in all circumstances?
Well, one of the things we try to do at our firm is establish a baseline of credibility with the regulator that you're dealing with, because it may come a point when you have an ask like you just talked about, and you want to be able to say, hey, I've complied with all your information requests and subpoenas. I've done it on time. I've given you fulsome productions. I've given you, where you think it might be helpful, some explanations. I'm not just dumping things on you. I think you can appreciate the situation we're in, 2 formidable or 3 more, government or regulatory agencies. And now, for efficiency purposes, this is what we're asking you. So I think for me, the important thing is establish that baseline of credibility so you can make the ask.
And in terms of cooperation, obviously that's an issue of ongoing evolution. The notion of cooperation has changed a lot over the years, particularly in the Department of Justice and in some of the banking regulators. How do you deal with the fact that different entities have different standards in terms of what it means to be fully and completely cooperative in an investigation?
I think that's incredibly challenging. because each entity believes that they have the right standard. And in my experience, they have not been afraid to remind you of what the right standard is and to say that, it doesn't matter that there's another standard, this is my standard. And obviously that can have concrete effects on how your client produces documents or prepares for testimony or who at the client you make available. And it's an area where the government has a huge amount of power, and defense attorneys only have the ability to play nice and comply with requests and make requests and hope that you've laid the groundwork to be able to have some sway there. So I have found that very challenging, and I think that government regulators do not necessarily talk to each other or care what the other is asking of the company, because what's important to them is what's most important to their case, not someone else's case. And so I think it's incredibly difficult when you're making a decision about whether to bring someone in if one person is going to be asking something and expecting them to be answered, and another person is going to have a different standard they're applying.
Right. Parvin, thoughts on?
Yeah, I'll say it starts very early, right? If you have a situation and you're considering self-reporting, there's this challenge of self-reporting to who, right? And sometimes it's clear that there's a primary regulator, but there may be some other regulator that has a small piece of it. And if you fail to self-report to them, you may not get credit for self-reporting, right? So that sort of thinking through, how do I establish credibility with the regulators? How do I build up a rapport? How do I get credit for cooperation and self-reporting starts really from the moment you have an issue. Making that decision as to, am I going to risk not self-reporting to a regulator who I don't really think has jurisdiction or an interest here, but if I turn out to be wrong, I might be on my back foot when they come in.
And Parvin, you raised an interesting issue. Voluntary self-reporting is one of the most challenging inflection points that a defense counsel has to grapple with. In certain contexts, the antitrust context, if you self-report and are fully cooperative and you're first, you get immunity. So there's a race, if you're part of an antitrust conspiracy, to get in, self-report, get your client immunity. There may be other regulators on the scene who you're not going to get immunity, and frankly, you're handing over an attractive criminal or regulatory case to other regulators. In the Department of Justice, there was a big push with Lisa Monaco and others about the value of self-reporting, but there were exceptions to the self-reporting policy, and I think a lot of corporate defendants found that the benefits of self-reporting were quite evanescent and not real, and that you're going in, you're giving the government a case, and the benefit, because of these exceptions and loopholes, was really illusory. And in the defense bar, there's been a great deal of discussion. Why would I ever self-report if I'm not going to get anything tangible out of it other than guaranteeing a criminal investigation? So I'd love to kind of spend a couple of moments on the key inflection point to self-report or not to self-report. And when you have multiple regulators on the team, that challenge is compounded exponentially.
Yeah, so look, all of these regulators have put forth a patchwork, like you mentioned, of carrots to try and get companies to self-report. Many times the reward for self-reporting is a referral to a criminal investigation, so there is no reward. But many of these regulators are trying to create a race in the door. Like you mentioned, antitrust. I think the recent policies announced by Lisa Monaco had the same effect. And so even if you are of the view that many are, that the reward for this is negligible / is going to cost my client millions of dollars and put them in jeopardy, so it's not a reward, you still need to get to the bottom of the facts. And so the fact that these programs that have a race in the door exist means that you need to very fulsomely investigate the issue when it comes up as quickly as possible so that you can advise your client, okay, here are the regulators that this could potentially impact, here are the benefits of self-reporting or not. And then you make the decision of who do you self-report to, like Parvin mentioned. Antitrust has a huge carrot, but not every issue is solely an antitrust issue. It often implicates fraud or other statutes or other regulators. And so then you're making a decision of, okay, I go first in the door to antitrust, but I need to tell antitrust that I want to report to other regulators as well. So it's complicated. It's more complicated by the fact that DOJ in particular has an expectation that companies will gladly race in the door within weeks of finding out an issue, and that's just not practical or realistic.
Right. And Jeff, from your perspective?
Look, given how important the decision to self-report or not is, and I agree with Becca that you got to go in there and you've got to do a thorough internal investigation as if you were the government. And you've got to explain to the client why it's important to do that. You talked about a patchwork, so you've got to master all the self-reporting protocols and benefits of that patchwork so that you can have the tough discussions with your client. And look, we all know that the carrots have abounded in recent years, different programs. And so it's tempting to sort of lean that way because of the benefits. But because of all the pitfalls, I think you have to be very careful. And maybe it's just better to not officially cooperate around the edges, focus on remediation, and maybe you're not going to get the credit you were seeking under a formal program, but maybe there's some ground you can make up because you cooperated and remediated. And in terms of the investigation comes in, the grand jury subpoena comes in, the congressional letter comes in. Obviously, the first thing you need to do is establish who you're dealing with, who your points of contact are. You also need to figure out, how do I get my arms around the facts as quickly as possible, as broadly as possible, dealing with the very real prospect in today's world that some of the people you may be interacting with are whistleblowers. Because the federal government in particular has put in place so many different whistleblower incentive programs that really cause whistleblowers to come out of the woodwork. And so when you're doing your factual investigation and you're dealing with your control functions, audit, compliance, or risk, legal, you don't know whether a whistleblower is amid the people you're talking with. So you've got to get your arms around the facts as quickly as possible. You want the government, all of the different government entities, to give you some breathing room so you can do your investigation. What strategies have you used to go to the government and tell the government, we're doing investigation, we want this investigation to be independent, we will answer as many questions you want, tell us what topics you're interested in us looking at, we will scour the earth, just give us a month, give us 6 weeks, we'll be back to you. Hold in abeyance your investigation while we get to the bottom of it. It'll be much more effective for you if you let us do our work. And if you're dissatisfied at any point in time, go ahead and enforce your subpoena. Have you found that to be a successful strategy with certain government entities?
I have. I think the instances where that has not been successful are instances where there's a lot of pressure, either political or otherwise, to move forward as quickly as possible. But I have found that most regulators, most prosecutors would prefer you to do a little bit of work for them. You have more access to people and documents than they would. You have more resources than they would. And so I have found that particularly if you're promising, I'll come in, I'll make a presentation, we'll make these productions, they do give you some rope and they do give you some breathing room. And particularly after you've gone in and made a production and they see that you're doing a fulsome job, you're not hiding anything, then they give you more rope and you can be quite successful in either narrowing the issue that they're looking at your client for, or can give you enough space to both be an advocate for the company and also do a fulsome investigation.
I think that's right. I think it's critical to get that space because, oftentimes the sort of narrative is set by your first presentation to the government. And so if you make that too early or they sort of construct a narrative before the facts have been built, you spend the next months and years trying to change their minds, and it's not always successful. So you really want to get that space in the beginning. And I think it's part of building up credibility to say, we're moving as quickly as we can. We can get you these things, but give us the space to sort of also run our own process, and we'll, commit to presenting to you within a reasonable framework and all of it. I think the government is usually accepting of that. It's harder when there are multiple agencies because they're competing against each other a little bit as well, right? And you have to sort of manage that.
One of the issues we talked about at the very outset is the importance to have coordinated, consistent communication. And when you have multiple enforcement agencies and regulators, often in different jurisdictions, at a law firm, you're likely to have multiple partners. You may have multiple law firms representing the same client. That makes it more difficult to coordinate communication because you'll have different individuals with different expertise talking to different regulators, different enforcement authorities. You also have a situation we haven't touched upon yet of if you're representing the corporation, oftentimes you're going to have individual executives that are also part of the investigation, and you're going to have to communicate and coordinate with counsel for the individual executives. So you have all these different strains of communications that really do need to be coordinated, because from the government perspective, if you start to get different stories from the same client or ambit of clients, you're creating a real problem for yourself. So what are some of the things you do to make sure that someone is in charge, someone is running point, someone is ensuring that whatever messages, presentations are being delivered to the government are in fact completely consistent and you're not stepping in it?
I think you really need to be coordinated. And so tactics are, having, as often as you need, group meetings, right? Where the partners, sort of from the different firms or the different constituents or however it is are meeting and you sort of sharing information to make sure that everybody's up to speed, is on the message, knows the latest facts and all of it. And it, there's oftentimes clients see sort of those types of meetings as expensive, which they often are, because you might have multiple partners sort of, billing and the like. In the long run, I think they end up saving cost enormously because you don't have to worry about sort of taking back something that was said that wasn't accurate because someone had dated information or not all of the information.
We live in a society where we're conditioned to communicate instantaneously. And I think in this situation, we have to resist that impulse. It's more important to get it right than get it fast, particularly when you're dealing with different agencies and on your own side with different players. So I think you have to resist the temptation, work hard to coordinate. If the government reaches out, email, letter, whatever, before you respond, make sure everybody's on the same page and everybody agrees with the way you're responding.
And then usually, the person taking the lead is company counsel. But if you're going in and making a presentation and you're showing an executive's very salty email, the executive's counsel is going to want to know that you're not throwing their client under the bus, or if you are, that you're presenting the context they want you to present. And so for communication purposes, you really need to make sure that all of the individual counsel know what you're going to be saying to the government, and have the opportunity to provide context that they think is appropriate, because you wouldn't want that individual to go in and in testimony to really minimize or distance themselves from what the company is telling the government happened.
And wearing your government hat for a second again, when you have individual executives and corporations that are both subject to investigation, would one of your tactics ever be to try to create some tension between the executive and the corporation, to try to get the executive to come clean, or get the corporation to come clean at the expense of the executive? And how would you do that? And if you could answer it, also wearing your defense hat, if you're a defendant, representing a defendant corporation, how do you prevent against that?
Sure. I mean, so yes, you do try to, whether it's trying to pit one against the other or just pressure test, right? You're trying to do that as the government, and to do that, you interview executives separately, right? And you want them to have separate counsel, and you want to have a dialogue with that counsel separately, to make sure that it isn't just sort of they're getting the same message that the company wants you to hear, but that this person is sort of independently considering it. I think as defense counsel, it's again, if you're representing the company, you want to know what the executives are going to go in and tell the government, right? And so whether that's interviewing them yourself, that's what you're really pushing for, or at least being in a dialogue with their counsel to make sure exactly what they're going to say. So you're incorporating that in whatever position the company is going to take.
I found when I was a prosecutor that if you went out too quickly and tried to court either the individual or the company by putting the carrot out there, it could backfire. What I prefer to do when I was with the government is to sort of wait, not appear too anxious, create the impression that I don't really need cooperation. I have enough evidence where I can get both the corporation and the individual, and let the sort of pressure of time, the pendency of the investigation, the cost building up, the anxieties building up, and then wait for a moment before going out there and saying, well, there's always the option of this. And so if that was the way I approached it on the government side, then on the defense side, I also don't want to seem too anxious. I don't want to seem contemptuous of the possibility that might happen, because I don't want to send the wrong message that way. So I want to strike the right balance and keep an open mind, but I'd rather have the government make the first overture in that respect, if I can.
And we spent the first 30 plus minutes talking about how to defend against parallel proceedings. I'd like to turn to, I think, an even more frustrating aspect of parallel proceedings. How do you resolve them? Because the piling on, the anti-piling on process that the Department of Justice issued in May of 2018 was an outgrowth of the fact that there was a very clear perception that companies that were subject to multiple investigations were paying duplicative penalties, and the overall costs rose exponentially and unfairly because each agency wanted to get its own headline number, and the victim in that circumstance was not the government, but it was the defendant entity. So there was a policy issue that purported to say to the government, there's only one set of wrongs, one set of damages, one set of harm, and you're going to have to whack that up appropriately. And in practice, that has not happened. I'll be unequivocal. That has not happened. So many of these enforcement agencies and regulators are overtly political. They want their headline numbers. The bigger the number, the better it is. They report on it to Congress. They get more staffing, more funding. So there's an incentive for agencies and regulators to come up with the highest possible penalty, the highest injunctive relief, the more monitors they can. And there's this overlapping morass that the poor defendant has to sort through. So you're now representing a global corporation subject to multiple regulatory investigations, state, federal, global. What do you do? And how do you do it effectively? And can you have any meaningful impact given the political realities?
I think it's difficult, to be frank, because you have no power in that situation. I mean, you have some power because you have the purse strings. But the problem with the DOJ anti-piling on policy is it directed the DOJ to take into account other regulators and other regulators' settlements. Well, the DOJ is always the highest settlement, so that's never going to work out in practice. And I think in practice, what you see is other regulators, state AGs coming forward once they know, oh, this is likely to settle, it's been in the works for multiple years, and they come out of the woodwork because they want their moment of press, they want this big number. And it's very difficult to explain to the client why they should not only pay one sum, but 1 times 2 times 3, and you're exactly right. The total can start to outstrip or start to really outshine the actual harm that was caused there. And so the problem is the biggest heavy in the room, the DOJ, has no real incentive to ensure that they are taking less of the pie so that a state AG can take more. And you have the problem of the political reality means no one wants to say no to money and no one wants to say no to a settlement. And so it comes down to advocacy. It comes down to making arguments like you just made of this is not in proportion to the actual harm, and ensuring that everyone, you've been on this likely multi-year journey of cooperation, of advocacy, and hopefully you've built up enough credibility that you can have those discussions, which may or may not work out in reality, but it's another reason why you want to, like Parvin said, from the very beginning, be having as much of an open dialogue and building credibility as you can, because you will need it at the end.
I'll add, I think it's really important to know what matters most to your client, right? In some clients, it's not as much the financial penalty as they want one resolution, right? They want one day in the press. And so in those cases, the challenge is getting whoever wants a piece of the pie, that's fine, but we need this pie to be baked, on X date. Because I can't have a settlement with, regulator A, and a month from now, regulator B on the same conduct. If that's your client's goal, it means you might be inviting people to, look, take some pie, just take it now, right? Which is an odd place to be, but that might be what your client wants. Another goal might be, we don't want a settlement with DOJ, right? We don't want the stain of a criminal settlement. So if you can fight off the criminal authorities and turn this into a regulatory matter, that's a win. And so, then that is your strategy, right? But understanding what is sort of most important to the client can sort of at least help you navigate to try to get to that goal. You're not going to win the whole game necessarily, but at least you can implement their strategy.
I mean, this whole scenario reminds me of the scene in American Gangster when Denzel Washington and Russell Crowe are in the cell, and Denzel sort of makes a veiled threat to Russell Crowe. Russell Crowe just shrugs and says, "Get in line." That's how I almost feel like when you've got multiple regulators or agencies on you. So you talk in terms of good advocacy, and I think one of the things I try to do is a little bit of a woe is us or woe is me defense, like, oh, you're the SEC or the DOJ, you want this, like we're doing our best here, and leading to the point of like, what do you want from us? You can't get blood from a stone. We only have so many resources. We only, we'll work with you, but you all need to be reasonable too, because it doesn't behoove anybody like to destroy us or that kind of thing. So look, it's a little bit of wishful thinking, it's a little bit of psychology, but I think sometimes it helps to sort of put it out there and establish the dynamic in your dialogue.
And oftentimes you have the plaintiff class action lawyers
I didn't think about that.
waiting in the background. So they're perfectly happy to allow all of the criminal enforcement agencies, all of the regulators do all of the work, create this vast record that they just go to court, put in an amended consolidated complaint, and then seek a fortune based on whatever the market cap loss was when the investigations were announced. I very much agree with Parvin's point about if you're able to settle all of the regulatory and criminal matters in one fell swoop with one announcement, as an empirical matter, if you've disclosed them, almost always the stock of the company will go up when there's a global settlement, because the overhang will disappear. And almost always the market cap increase that coincides with the public announcement of a resolution will more than pay for the resolution itself. It is one of the very small things I'm able to go to the client and say, see, we added value at the end of the day. So it's an incredibly frustrating dynamic. The minute, I'm sure everyone in this room who deals with these situations feels the same way, the minute you know your client is in a global, parallel, criminal, regulatory, investigative position, you're going to have a miserable 3 years or 4 years. It just is. There's a minuet. You go through all the stages of grief. You then reach acknowledgement. You then get to the other side, but it's miserable. And one of the things I've found, and I'm sure all of you have found the same thing, and all of you have found the same thing, is you have to condition your client to what lies ahead, because it is a really miserable, protracted, painful, bitter, unfair, costly process. And it ultimately ends, and then you move on. But it's the only thing that gets me through the next 4 years when I think about the next 4 years. We've all been through this. I don't know whether anyone in the audience has thoughts, questions, suggestions to amplify. We have just a couple of minutes left on anything that we've talked about. Or whether any of the panelists have anything further to add.
Just wearing the government hat again for a moment, another difficulty from the government side of parallel investigations is, one governmental entity may want to position the individual players in a certain way, and another wants it differently. So for example, DOJ may want the company to be the victim of a fraud so that they can go after the senior executives who defrauded the company, whereas the regulators may see the company as at fault for not having reasonable controls or supervision and the like. And so again, both from the government side, that can be frustrating in terms of managing the parallel investigations. And then on the defense side, if you're reaching settlements with the difference, trying to navigate the different interests that may be competing against each other adds to just the complexity of what we do.
And actually, Parvin raises another point which leads to yet another point, which is often the case here. The negotiation of the language of the settlements is unbelievably important. It's unbelievably important for collateral consequence purposes. It's unbelievably important for follow-on civil litigation purposes. It may be unbelievably important for indemnification purposes. So you may be willing to pay more money to the Department of Justice to get a more benign statement of facts, which is interesting. You may be willing to negotiate with the SEC to avoid having a neither admit nor deny framework, as opposed to admitting certain wrongdoing, because you have billions of dollars of follow-on civil litigation in the offing. So those negotiations, and then what you wind up having in those negotiations, if you have 10 different regulators and enforcement agencies, is you have to make sure that all of the enforcement agencies and all of the regulators agree to give you the same language, because if 9 of the 10 are willing to, but one stray enforcement agency insists on finding intentional wrongdoing, everything that you've been negotiating for the last 4 years carefully falls by the wayside, and you've captured nothing of what is important to your client. So the stress involved in negotiating with all of these different regulators with different priorities and different agendas is really, really complicated. Thank God that a lot of the prosecutors and regulatory lawyers want to go into private practice and don't want to completely emasculate you because they're going to want a job at some point in the future, as our panel is proof of, which may be the only saving grace that we have in this miserable dynamic. Lee Richards.
You've all talked about the difficult decision about whether to cooperate. But you've also said that it's typically the case that you go in early on and say, giving a 6-week period, so isn't that a promise where you've done your best to cooperate? Aren't you setting up expectations that you need by cooperating with them?
Yeah, I think you are. Look, we kind of glossed over that because there aren't a lot of corporations that are not going to provide cooperation with criminal authorities because of the consequences. But yes, if you are going to the prosecutors and saying, let us do our own investigation, you are essentially waving the white flag and saying, you're going to get full cooperation from us. The couple of times that I've had clients who did not want to cooperate, there was a type of ugly that I can't even describe in terms of the prosecutorial reaction.
Yeah, because it's the DOJ's, it's the regulator's expectation that a company will cooperate.
If it wants to remain a company.
Exactly. Is there a question in the back?
Oh, yes, please.
Hi. So is there some concern about state and local regulators picking up actual or perceived slack in an absence of prosecution or with pulling back from federal regulators and law enforcement?
Did you hear all of that?
Yes.
Okay. Yeah.
The question was about whether we expected state regulators to pick up the slack or perceived slack from federal regulators or prosecutors. Yes, that's what happened that's what happens in every administration, wherever the side of perceived slack is coming from. I think we talked about earlier that this is a very timely discussion because my expectation is parallel investigations will only intensify, but with more politics and more distrust among regulators, which will make our lives more difficult.
And I would expect that you're going to see a much more aggressive state and local enforcement of the criminal laws over the next 4 years than we've seen, particularly with the Democratic state AGs organizing themselves. Also, what happens when you have a period of when you don't have regulatory enforcement and criminal enforcement, that is when you have the major scandals in the next administration. You've seen that with the financial crisis. You've seen after Bush. You saw that with Enron and WorldCom. There's a period of time when if the companies know that no one is watching them and they can get away with proverbial murder, they're going to. And it will all wind up coming to the surface when regulation and enforcement picks up the next go round. We've gone over our time, and Bruce is going to give us the